The Graduate Institute's Geneva Trade Platform proudly presents e-commerce terminology for trade negotiators.
Online consumer protection. The simple definition is safeguarding buyers of goods and services and the public against unfair practices in the marketplace. So online, who decides what is unfair? Who is responsible for the goods, their description, their supply? Who decides and judges what is fair? And where, given the internet's global reach, is the marketplace itself? So it's, as with other terms we discuss, really no different to consumer protection as it's understood in general practice. Awareness of consumer protection is key. It's publicity. If I'm a business based in one country with no legal footprint in another, but that sells there via my website, how practically liable am I if I choose not to respect consumer protection laws that apply to my customers? So consider the importance of the full chain, the My Hermes hack, the distant selling and multi-level stage courier delivery process spam phishing attack that I mentioned in the spam section. Think broadly about this. People don't think of online consumer protection as specifically online, now that online commerce is normalized, even for those who haven't yet had an opportunity to do it. So who gets what value from online consumer protection? How does the consumer know that their rights are being restricted or were restricted versus being taken advantage of post hoc by a third party who may be inventing that restriction for their own gain? Online dispute resolution is also an important factor here, not just the actual protections themselves. So consider digital claims hearings, which is an area that's still today actually very paper and traditional based, often with needing to attend a court hearing, for example. Returning faulty goods is likely the largest implementation of this, with every provider inventing their own approach to this rather than there being any standards, both within geos, within jurisdictions and cross-border. There's an exploding number of bodies promising consumer protection, but how does the typical consumer know where to turn? This goes back to my earlier mention of publicity. So examples in the United Kingdom could be Which, a private organization. It could be the Office of Fair Trading, could be review sites, some of which are independent, some of which are stealthily not independent. What will any of those do for me as the consumer? Which do I turn to? How easy is it? How much does it cost? How do I find this information out? So what are the government mandated responsibilities of businesses in their country and outside their countries to their populations of consumers? And again, to specify, to build out that earlier example, if I'm a business in Australia selling to a consumer in Germany without any business footprint, any assets in Germany, when the customer asks to return a product I've sold to them over the internet, delivered to them from a warehouse in Italy, for example, I can treat that customer however I like if there is no international framework in place.
Thank you, James. This is an area where delicate balances need to be struck by trade negotiators. It is a terribly important area of regulation, and consumer protection has always been one of the legitimate policy concerns for regulators to impose disciplines in the marketplace. Now, of course, the online aspect of it is relatively new. And online consumer protection always raises challenges, not least of which are jurisdictional challenges. But from a trade perspective and how trade negotiators and trade agreements deal with this matter, there are two important things to highlight here. The first is trade agreements have never been, and I don't think will be, the right contexts or areas in which standards for online consumer protection would be created. These are areas of trade negotiations where certain principles may be agreed, but not exactly to set internationally agreed standards for online consumer protection. The point here to keep in mind is that this is an area that requires a more intensive international cooperation. The second point to highlight here is the kind of obligations that trade agreements can usefully have is the obligation to have an online consumer protection law, because in many instances, some countries don't even have online consumer protection laws. And given the fact that this is an area of increasing importance, we see in regional trade agreements increasingly the obligation to introduce a law to that effect. A trade agreement would not get into what the content of such law should be or how it should be structured, but merely the obligation that such law would have to be created. Now, of course, all this is about creating a conducive business environment to facilitate trade. But the last point I would make here from a trade negotiator perspective as well, and this is something in the minds of trade negotiators and trade policymakers, is to strike the right balance in trade agreements, that while this is an important element of regulation in order to protect consumers and prevent fraudulent practices, they should not be abused also as a pretext to create disguised restrictions or inhibit cross-border and cross-jurisdictional business in the name of consumer protection. We can see immediately from these two competing objectives that there's a very, very delicate balance to be struck here, particularly in the context of trade negotiations. So thank you. With that, I'm back to you, Dimitri.
Thank you for following this course on online consumer protection. Additional readings and materials are available below. You can also ask questions and discuss the course with fellow students using the link below. Follow us on Twitter, LinkedIn, and Facebook, and stay up to date with the Geneva Trade Platform.